Good day and welcome to the Patently Strategic Podcast, where we discuss all things at the intersection of business, technology, and patents. This podcast is a monthly discussion amongst experts in the field of patenting. It is for inventors, founders, and IP professionals alike, established or aspiring. And in this month's episode, we're going to tackle the often misunderstood concept of inventorship. We can't think of a better time to bite into this topic than when going into Thanksgiving weekend, because aside from a delightful conversation with the in-laws about politics over some dry turkey, few things can get more contentious and be full of more misconceptions than discussions of inventorship. In the US especially, patents are granted to inventors. More often than not, that's more than one person, and the ideas themselves are fluid concepts that often evolve through many handoffs, from initial conception through implementation, and sometimes even throughout patent prosecution. But how do we determine who all should, and is legally required to be, officially named as an inventor? In the constitutionally expressed interest of protecting inventors and the conception of their ideas, failure to include the right people can be a death sentence for a patent and grounds for invalidity. After he passes the stuffing, Daniel Wright, partnership manager and patent strategist here at Aurora, will lead a deep dive into the origins of inventorship, break down who is and isn't eligible for inclusion as an inventor, and explain how improper inventorship could lead to more heartburn than Aunt Hilda's green bean casserole. Daniel is joined today by two of Aurora's favorite in-laws, David Jackrow, president of Jackrow Consulting, and David Cohen, principal at Cohen Sciences. All right, take it away, Dan.
So today, though, we're going to be talking about inventorship, because I find that this is definitely, I think, one of the most client-facing sides of our practice. Some of the more, certainly critical, but aspects of application drafting and some of the procedures before the patent office. A lot of clients will honestly just take your word for it, or they just don't see that section of it. But when you get to inventorship, this is then something that they kind of directly have to deal with. They have to provide you the names of the inventors for an application, and this becomes very, very personal. I mean, people like seeing their names on important, valuable documents, and especially when you get a lot of inventors come out of academic institutions, academic backgrounds, where then anybody who breathes in the meeting room during group meeting gets their name on the academic paper, and we know that's a different standard for patents. And so this is a conversation I find myself having fairly frequently with clients when we get to this stage of application drafting as well. Who actually gets to be named on the patent, who gets included, who doesn't get included, and sometimes. Sometimes people are maybe feel a bit hurt when they realize, so-and-so shouldn't actually go on this patent, because everybody wants to be generous. Certain people who were involved and again, if a lot of people approach it like an academic paper. So, however, I will say this: as I was digging more into this topic, I ended up finding a little bit different nuance. So this talk goes in a different avenue than where I expected it to go when I began. But we will begin, though, with inventorship 101. So unique to the US, as I'm sure you know, or maybe not exactly unique, but particular to the US, is that US patents, because of how the Constitution is phrased, are issued specifically to the inventors. And so then we have the secondary system of assignments and the applicant that's kind of developed a bit with law over time, to make it more clearly, the real party of interest, the company that's pursuing the IP rights. But still, fundamentally, you have to name the inventors, and it's a big deal to get inventorship right. And this is distinct from some other countries where they kind of hand wave, or they care less about who was the actual one who did the work. They care more about who is the the judicial law-abiding entity that is pursuing the intellectual property right that the government's going to grant. And then next, though, inventorship is fundamentally related to conception. It's that who, with regard to the invention, actually sat down and conceived of it, put together enough of it to make it work, so that it is apprehensible, it is understandable to those of the skill. And that particular reduction to practice is not fundamentally required. And this is the bit that I think really catches a lot of inventors clients off guard, is that, they say, okay, well, we have a senior science staff of 2 or 3 people who worked on this, but we have some lab techs or we have some engineers that we gave them some specs. We gave them, the head science staff came up with something and they gave it to the engineers, and then the engineers went and built it. Like that was really important work. Yeah, and naturally, I think as everyone wanting to be a generous kind person wants to include those engineers, but then I always have to kind of draw them back and ask, well, did those engineers actually add any new elements to it? Did they change the design? And sometimes that can happen in some dependent claims, like maybe an inventor an engineer came up with some variant or did have to tweak something that becomes then claimed and therefore promotes them. But for many times the answer is well, no. The chief science staff, the senior science staff came up with it and they handed it to the engineers or to the lab techs, and the lab techs did very valuable work, but they never did any of the interpretation and they never actually tweaked anything. And so despite that immense value of the engineers and the lab techs, they don't get named by the standards of US patent law. But increasingly, inventions are becoming collaborative efforts. If you look at the trends, I don't have the trends with me here, but the number of the days of single inventor patents is behind us. You still get some, but increasingly patents are naming two or more inventors. And so the CFR has some what sounds fairly obvious bits here about joint inventorship, but I keep seeing it come up in every bit of case law on inventorship I see, so I think it's worth repeating here, is that joint inventors need not physically work together at the same time, especially now in this work from home era. Very seldom now are people physically working together at the same time. Similarly, joint inventors need not make the same type or amount of contribution. So, as somebody only contributed one element to the invention and somebody else came up with the other 99, well, the one is indeed literally a contribution. So therefore he or she will be named. And then finally, joint inventors need not contribute to every claim. Need not contribute to every claim, to stress this, because the invention, and this leads us to something I've kind of hinted at, is that the invention, as we know, is defined by the claims. The bit that the government cares about, the bit that the examiners care about, is that they're going to look at how your invention is discussed as claimed. And so to be a joint inventor, when you've got this list of your 20 plus claims or so, you don't need to be an inventor on every single claim. As long as you're an inventor on one claim, that qualifies you as a joint inventor. So again, similar to that prior point, you don't need to make the same amount of contribution. As long as you've contributed literally something to the conception of the invention, you count. And so with this, though, strict definition, a strong relationship between the invention as claimed and then who's an inventor, this then results that the inventorship on the application can change as the claims change. And fundamentally, this will most likely occur when you have a restriction requirement. So you've got a device and a method, or perhaps you've got two closely related inventions that you pack together in one application. You sent it in, you get a restriction requirement, and one inventor strongly worked on the device, and another inventor, or I guess I have, to be specific, one inventor was only to the device, and then another inventor was only to the method or to the other related device. And then you get a restriction requirement, and you're required to split them out, and you split them out evenly, such that there's only one inventor now on this new application, or on the current application, and now the other inventor is only on the divisional. you are required to change the inventorship of those applications. No longer now you've divided out the material along the conceived lines along how they're claimed. So inventorship changes. Now, technically, this can occur for other types of, whenever the claims change, technically your inventorship could change. Perhaps for certain rejections, 101 or 112, you drop something or you change something, and now someone's contribution gets eliminated, or you change your claim scope, and something gets left out now. They've no longer contributed to part of the claims, which, as the claims define the invention for that given application, then they have not actually contributed to the invention. And again, this could happen with prior art rejections. It's novelty, non-obviousness. Perhaps you change something that in the language that tweaks what elements are included, and maybe you're cutting somebody off. I'll say you're very unlikely adding anybody to it in this process with how the mechanisms of office actions work. And similar, I will say, very seldom do you actually overcome a prior art rejection by removing things. Normally, you're adding more detail from your specification, which is probably just going to further increase people's contribution to it. But technically, I guess it could happen in some weird way. But the fundamental point here is that one invents over the prior art. Is that the standard process of filing of acquiring an issued patent is you put together an application, you send it in, and for every case, the examiner is doing a search. The examiner is going and looking at what else is out there about this field, about this technology, and is the invention as claimed, useful, novel, and non-obvious over what else is out there.
Yeah, Dan, that's a great point. I think you're right. It's kind of rare that this kind of situation where you have to amend something that changes the inventorship especially in the prior art rejection area. I remember a case a couple of years ago where it happened to us though, and it almost caught us. We almost made a mistake in the inventorship in the end, because what we had to do is bring in a sort of a very different limitation to get around the prior art, and that limitation was it was different, and it had a different inventor who had contributed to that. And so we got the allowance, we were looking at paying the issue fee, and only when we were doing our final review, we were like, oh, wait a second, these claims changed. Are the inventors still right? Because we had been working with the client, we knew their portfolio, and we knew that particular limitation had a different set, of inventors. So we did catch it, but yeah, it's a great point that you bring up, because inventorship is really important. It could invalidate a patent if you don't get it right. Yeah.
So I'll be talking about that, the actual legal consequences in a later slide. But yeah, absolutely. And we're approaching now this fundamental equivocation, because some of the case law I stumble on kind of surprised me. So there seems to be an equivocation, and I intentionally phrase this a bit cheekily, of being an inventor versus being an inventor. Because there's this whole relationship, as you just described, as between this analysis of the prior art. There is an analysis of the prior art that is relevant to the issuance of any issued patent. That must occur. And therefore, if your inventorship relies upon the claims, one would think then that there should be then a very strong relationship between conception, inventorship, and prior art. But some case law I'm going to go into here actually suggests otherwise. It actually suggests that the right to be named on a patent application is in a certain way distinct from sort of the status of sorts, to say, of being a named inventor on an issued patent on the other side. And some current case law actually suggests that the details of a prior art analysis are actually somewhat irrelevant for this first bit of whether or not you are named as an inventor to begin with. And it gets a bit weird, but so at first I put together a simple kind of example here that that this does make sense to me. So, fictional example here about whale hunting. Ishmael and Queequeg are trying to develop the ultimate whaling harpoon, and Ishmael, he comes up with this new grip for holding the harpoon, and Queequeg develops a new spear tip, and they put together their patent application, and they've got a claim that includes both elements. You got a whaling harpoon with Ishmael's grip and Queequeg's spear tip. They submit that to the USPTO, and the USPTO determines from their prior art analysis that Ishmael's grip is obvious over like a spearfishing product out of a Base Pro Shops brochure. And so that bit is, that part alone would perhaps be seen as, not patentable over the prior art, but they find that Queequeg's spear tip is indeed novel and not obvious. And so the case issues with both of those, the claim still reads the spear tip and the grip, and the case issues with both Ishmael and Queequeg as inventors. Now, there's no obligation to remove Ishmael as an inventor from the patent, even though it was Queequeg's contribution that actually was found to be the novelty, the non-obviousness that pushed the case to issuance. It was a collaborative, as you'll see some of the language from some of the specific case law examples, that it was still a collaborative effort. They indeed worked together. The claim elements are there, even though Ishmael's contribution was found to be obvious. It's still in the claim. So as long as it is still in the claim, then indeed both Ishmael and Queequeg are inventors. Now, had this been divided out, had this been split up into two different cases, well, then it feels kind of weird, because we would be in a situation where, you split it out, and Ishmael's case never gets issued because it's obvious, but Queequeg's would, because it's novel and not obvious. And so then the only patent that would end up out of that system would be Queequeg's. So that to me still seems kind of like an odd conflict there, and this just sort of continues. So first case law example from '98, Panu versus ILab Corporation. And the story generally goes like this. So Panu invents a new lens implant, so literally a replacement lens for your eye that's surgically inserted into your eyeball. So he invents a new lens implant, and he files for a patent. And during this process, he's already filed. His rights are secured. He goes and he meets with a man named Link to discuss a license for manufacturing. I've got this new lens implant. You make similar things. How about I sell you a license to make my new lens implant? And during this conversation, Link actually makes a suggestion to improve the lens. He suggests that you could make the lens have just like a single piece of a certain type of plastic, I believe, that instead of having some of these distinct components you have to put together, you could just make it all as one, and you get some other improvements because of that, rather than just beyond just the ease of manufacturing. And so then with this idea, Panu then goes and files a CIP of his original patent that includes this new improvement, but he only names himself as an inventor. There's no mention of Link on this CIP. And during the discovery, it actually comes out that Link was a bit surprised when he eventually saw the CIP and his name wasn't on it. So jump forward a bunch of years, and IOLab, who has seemingly no relationship to Link, it's just another manufacturing company. Panu asserts that IOLab's been infringing his implant design, and as is standard, IOLab countersues that the patent is invalid. And there's a bunch of reasons why it's invalid, but the one that's relevant here is that for improper inventorship. Somehow he figured out that about this conversation with Link, that Link was not named on the patent, And so their argument goes like this, that Link should actually just be the only inventor on the CIP because Panu's contribution was already prior art. Like that material was already out there. He had already been making offers for sale. He had already filed for a patent on like his portion of the invention, because the important bit of the CIP was this single body form that Link, that was, as we can tell, seemingly Link's idea. So they go in strong with the fact that no, not only should Link should be the sole inventor, and the court decides that sole inventor no, co-inventor probably. And so some quotes here is that during this meeting with Link, that Panu was doing more than just simply providing Link with well-known principles or explaining the state of the art. Like this was a personal meeting between the two. They were talking specifics about what Panu had already done, the details of his implant design. And so it was more than just handing him a textbook or providing some general principles. And then, quote, because it is undisputed that the invention was conceived while Link and Panu were engaged in a collaborative enterprise, it is furthermore undisputed that Panu conceived significant aspects of the invention. Panu is certainly at least a co-inventor. And again, this is because the claim did claim more than just the single manufacturing, the single body form. It had all these other details that were related, that were of Panu's contribution. Now, note, many of these were from the original filing and that were of stuff that he had been talking to people about during his offers for sale. So two things that stood out to me here, and the court briefly touches on it, is that inventorship can be corrected. So inventorship is a death sentence for a patent. Improper inventorship can be the nail in the coffin. It grounds for invalidity if, though, you demonstrate that the applicant was trying to pull something. Like if they're acting in bad faith, they're trying to hide a contributor, if they're trying to play games with the patent office, and you can prove that, then it just outright improper inventorship becomes grounds for an invalidity. And that's because, again, of how the Constitution is written, that IP goes to the inventor. If you've got improper inventorship on there, then it's a null legal document because it's not to the inventor. However, if they legitimately made a mistake, they are allowed, the patent holder is allowed to just go back and correct it, even after it's issued. And I note they actually, in this case, do actually have to do it. So there was a kind of a somewhat curious section I found where it says like, if it's found that they honestly made a mistake and it's got improper inventorship and they're notified of that, and then they don't do it, well, then the patent's invalid. They actually have to follow through on correcting the inventorship when improper inventorship is discovered. So in that sense, some of this topic does feel, in certain circumstances, a bit kind of, I don't know, irrelevant in a way of like, well, sure, they could very well have improper inventorship on this case, but they could also then just easily go fix it. So this was just one of many things in ILab's countersue of invalidity. And so the amount of focus it got here does feel a bit weird because of its seeming practical, easy to fix. But then the other thing that kind of bothered me about this one case is the fact that this was a CIP. It feels like that I'm a bit confused as to how the court did not seemingly recognize some of the consequences of the fact that this was indeed a CIP. So many of Panu's contribution, although yes, he's been out there talking about it, it should have already been, those elements would be safe from the prior art analysis because of the CIP. And then similarly, in order to claim priority back to a previous document, in the US, you do generally need one, continuity of one inventor. So it would be weird to me to then eliminate in a CIP the linking inventor, yeah, that just seems like a formal incompatibility, that you're claiming priority back to a CIP, to a previous document, but then eliminating the inventors of the previous document, even though it's supposed to inherit all the subject matter from that document. So, yeah.
Well, this would hinge a lot on the exact wording of the claim.
Yeah.
Right. I mean, if the claim were entirely focused on what the new guy Link invented, that would be one case. But if there were other elements, pre-existing elements from the original application, which I don't think that would be unreasonable, right? You'd be contextualizing you contextualize the new elements with some of the pre-existing elements. So those would be different.
Yep.
Different scenarios.
Yeah.
Yeah, that's a good point. I actually had a similar kind of a thought as you were talking about this, Dan, and I'm wondering if you've come across any explanation like this. Then I know that, and examiners maybe sometimes don't agree, but a claim is supposed to be allowable. It's not supposed to be able to be rejected by a 103, even if all the claim elements individually were previously known, but together they're non-obvious.
Yeah.
Maybe somewhat of a corner case, but I think it just came to mind that it kind of does make sense to me that picking out each limitation on its own and who invented it and is it in the prior art, it can yield the proper analysis in the end, whether a claim is allowable or not, but not always,
Yeah.
So there's this gray area in a way.
No, I'm glad you phrased it that way, because that is, I think that is a very valuable consideration here to have, because indeed it's very easy to, especially because you are supposed to, in this inventorship analysis, say, okay, party A came up with element A, party B came up with element B. But indeed, you're right that you're supposed to consider claims, as a whole, each claim holistically, and that you're not just splicing out every line and staring at each element in a void. So yeah, indeed, that could very well be the motivation and solve some of this discrepancy. But I got one more case here that it's this again, and so I looked a bit farther, because this Panu case comes up. It comes up a lot. It seems to be one of the standard cases now to reference in these sorts of situations. And so a much more recent case from 2020, and it's now it's now been appealed, or it's waiting. It's trying to get cert from the Supreme Court. Dana-Farber Cancer Institute versus Ono Pharmaceutical Company, and it's a similar sort of similar story here. You got a bit more though prestige and some bigger parties involved. Hence why this one's maybe going to the Supreme Courts. But it involves the 2018 Nobel laureate Dr. Tasuku Honjo, who is attached to Ono Pharmaceutical for this patent case. He received the reward in like medicine and physiology, and then two scientists, Dr. Gordon Freeman and Dr. Clive Wood, who are attached to Dana-Farber for this case. And this is all about antibody-mediated cancer treatments that involve the PD-1 receptor. So just briefly, it was a way of kind of identifying cancer cells versus healthy cells, and then some instances where cancer cells are not showing certain receptors. And so of an ability that with antibodies, if you could discern these situations and bind to the receptors, you can develop, and these guys did develop treatments that allow for greater selectivity of cancerous versus non-cancerous cells. So the story kind of goes like this. In the early 90s, Honjo identifies the original gene sequence and the receptor. And he and his lab are doing some fundamental work there on the genomics and the proteomics of the receptor. back then in the 90s. And then in around 98, Honjo meets with, this is when he gets involved with Ono, the company, and meets up with Dr. Wood, and they set up a collaboration. And so, Honjo and Wood sharing information. Independently, Dr. Freeman is independently researching like ligands of this type. Originally kind of unaware of what was going on with Dr. Honjo and Wood, but eventually he is brought into the fold. He joins the collab. And during this process, they actually, Dr. Freeman's work does lead to, he kind of, before he knew exactly how it would interact, he ends up discovering something that does indeed bind to the PD-1 receptor. And that becomes a huge jumping point, starting point for a lot of the powerful research that comes subsequently. But curiously, to add to the drama, in 99, about a year into this collaboration, Dr. Freeman and Wood go ahead and file a provisional in the U.S. without Dr. Honjo. And the court makes a point, though, that these are not the patents at issue, but definitely is going to be a bit of a, probably adds to the drama and some of the ill will between these parties. But notably, in 2000, the group then does go and publish a journal article on what they've been working on. In June, though, of 2000 is when Dr. Honjo learns of this provisional that he's not named on, despite that it's in this ballpark, it's in the line of work that they've been working on. And Dana-Farber declines to add him. Dana-Farber tells him that he can go seek the normal remedy available to parties before the patent office, and he can go start his legal complaint. But no, Dana-Farber refuses to add Dr. Honjo to this 1999 patent application. But again, no, these are not the patents at issue, but it's probably very upsetting to Dr. Honjo. So much so that by the end of the year in 2000, he stops sharing results. So he kind of is further withdrawing from the group. There is apparently one more group meeting they have, but by late 2000, Dr. Honjo is no longer freely sharing his own experiments with his group. He's got a team of his own, and they're sort of looking in a different direction, but they're certainly within the scope of this PD-1 receptors, similar receptors, and groups that bind to it. So in 2002, then Dr. Honjo goes and files his own patents without naming Dr. Freeman or Wood. He kind of returns the favor, and he's on these patents, limiting himself to work that is much strongly supported by his own group's experiments. He actually avoids expressly naming the ligands and the work done by the other collaborators. But the court does note, quote, "It is not without interest that in Dr. Honjo's acceptance speech for the Nobel Prize, he credited Dr. Freeman as a major collaborator in his work." So Honjo now has his own applications that don't name Dr. Freeman or Wood. And then Dana-Farber goes, hey, Dr. Freeman and Wood should totally be on your patents. Then therefore, we should then, because they have an obligation to assign to us, we should be co-owners of this patent alongside Ono. So in the arguments presented to the Federal Circuit, that the Ono makes the following, to simplify, makes the following arguments: that the subject matter of these given of the patents, of the 2002 patents at issue, they do say the subject matter is far enough removed from the original collaboration of Freeman and Wood that we're not claiming the PD-1 receptor or something. We're not claiming the specific ligands we're claiming methods and other aspects that were born out of these subsequent experiments done without Dr. Freeman and Wood, that were done by Dr. Honjo himself and the immediate his immediate collaborators at Ono, rather than with the Dana-Farber Institute. Similarly, furthermore, they argue that the patents were actually issued over the 1999 filing. So these patents have already been examined. Those those patents by Freeman and Wood are out there, and these patents were issued over that. So, these are obviously, they are obviously novel and not obvious by the standards of, the presumption of validity of issued patents, that there is a distinction between the 99 filing and this new stuff. And then furthermore, they argued that year 2000 journal article, disclosed the scope of what you could say were Dr. Freeman and Dr. Wood's contribution. That sure, even if you make the case that they were influential and they had done some original work that led to the 2002 patents at stake, all of that subject matter should just is prior art because it was disclosed in 2000 in the journal article. And so it goes so far as the court interpreted this, that Ono urges us to adopt a legal rule that once a contribution is made public, it, quote, no longer qualifies as a significant contribution to conception, end quote, from the applicant's brief. So, I mean, here is very much the crux of the matter is if the claims define the invention and claims are to be interpreted over the prior claims are only ever issued over the prior art, then shouldn't then there be an analysis of the prior art towards who gets to be named an inventor on this case? And so, yes, here strongly, Ono is presenting Dr. Freeman and Woods had already disclosed their material in 2000 from this journal article, so there's no need to name them. But the court ultimately did decide with Dana-Farber. It's like, well, no, conception here is the key, and that your work, the work of these 2002 patents is, dare I say, derivative, or it is close enough that such that, the conception is complete when an idea is definite enough that one of skill in the art could understand the invention. And so that the work of these 2002 patents is such that from that contribution, from the contribution of Dr. Freeman and Dr. Wood, that the details of what is claimed in 2002 is still lumped under that conception performed by Dr. Freeman and Wood. And then the decision outright says it here that, quote, joint inventorship does not depend on whether a claimed invention is novel or non-obvious over a particular researcher's contribution. But I'll be honest, this feels kind of weird to me. That quote just above about whether or not one of skill in the art could understand the invention, that kind of feels like an obviousness type assessment to me. That you're claiming something that would be considered obviousness, obvious from a person of one skill in the art, from a certain understanding, from a certain point of time. So yeah, this case feels weird to me. And finally, Ono has petitioned for cert from the Supreme Court, outright asking whether the Federal Circuit erred in adopting a bright line rule that the novelty and not obviousness of an invention over alleged contributions that were already in the prior art are not probative of whether those alleged contributions were significant to conception. Really just, again, focusing in on this item. Because, and I'll be honest, I'm not quite sure where I fall in this, on this topic. I can kind of see early on with my simple example about Ishmael and Queequeg, how that goes that way. But in this case, I will say with Dr. Honjo's, Freeman, and Wood, like if your own inventions can become prior art for yourself because you already disclosed stuff, is that related analysis not relevant when you've got multiple parties at stake here?
I wonder if part of it is maybe practical in a way that when an entity is filing an application, they don't know every piece of prior art in the world. And like even after something is allowed, like it goes through litigation and tons more prior art will pop up. Mm-hmm. And so that seems like a practical thing that would be a very difficult bar to meet. you must know every piece of prior art to get the inventorship right. You know what I mean? So
Yeah.
that seems like I don't know if it's like in any of these judges' minds when they're making these rulings, but I could see how it would be a difficult system to abide by.
Yeah.
You know what I mean?
Yeah. Yeah, and that's also why, you know, I started this section kind of with this. There's perhaps an equivocation we make about being named an inventor, is that there's a first standard for getting your name on the patent to begin with at filing, and then maybe it's not so clearly distinct, but maybe, you know, as the claims change, there's maybe a bit of a game to be played as to who remains named on the application. But being an inventor such that you are named on the application to begin with is still being an inventor versus, you know, declaring yourself an inventor only once the case is issued, or once the case is upheld or changed in court. Because this maybe causes a bit of a mental shift for me, because, you know, I have for a while, you know, to a certain extent, only ever considered, it's like, all right, cool, you've come up with something, you the inventor, and I'm going to call you the inventor for the practical reasons of writing things down. But deep down, maybe there's a bias of like, well, you're not actually an inventor until you get an issued patent. Yeah, that, and from the, you know, the legal definition to a certain extent, maybe that with this analysis isn't quite so the case, or maybe it is. This is why I wanted to bring this topic up, because I was not expecting this level of nuance and this strict relationship between prior art and declaring an inventor. Because sometimes it seems like the prior art is clearly playing a game with who is the inventor, who are the inventors on this case. But then there's been some strong decisions that have been standing for a while. I mean, that Panu case, I believe, was from '98. And I continually was seeing it referenced again and again, looking for modern case law. So it's been upheld. It's been used many times. And it quite clearly states that no, novelty and non-obviousness analysis are not relevant. Are not relevant towards a strict line drawing around who is an inventor or not. So
it is interesting. I agree with you. I wasn't expecting the level of nuance.
Yeah,
an interesting topic, and like I guess I wonder if if you're reading a journal article and you learn something, okay, the author of that article is not an inventor, right? I mean, it's prior art, it's published, it's public domain. But if you're working together with someone in a group, I mean, it's a lot harder, right? To like separate one person. Would you have come up with this if you hadn't had that conversation with them? And of course, Dan, these are intellectual contributions, if you will, like intellectual discussions with another party, not like talking with a technician about how they're going to run an experiment, but talking with someone about what to do about the invention. And especially, I think both cases that you said, especially the second one, there's clear motivation for one side to not name the other as an inventor, right?
Yeah.
So I bet you those factors are in the minds of the judges.
Yeah.
To figure these things out,
Yeah, this was far more interesting than I thought it was going to be when I started looking into inventorship. I thought we'd be having a fairly straightforward talk about, reduction of practice isn't necessarily required for inventorship. And here are some, anecdotes of times I've had clients, not get this or want to fight back, and we'd be sharing those types of stories. But yeah, there seems to be a weird question here. There's certainly practical elements of this, indeed, trying to get inventorship exactly right, having to like remove people down the road because some bit of prior art the examiner found in the fourth office action, making that the standard seems weird. But then this kind of open-endedness of it also feels weird to me. So yeah, food for thought, definitely something I'll be thinking about in the more.
All right, that's all for today, folks. Thanks for listening, and remember to check us out at aurorapatents.com for more great podcasts, blogs, and videos covering all things patent strategy. And if you're an agent or attorney and would like to be part of the discussion, or an inventor with a topic you'd like to hear discussed, email us at podcast@aurorapatents.com. Do remember that this podcast does not constitute legal advice, and until next time, keep calm and patent on.